Question number 16 reads, the government decides to ban a documentary film which has been critical of its policies. Which among the following fundamental rights is violated in this case? Now this is an understanding and application based question. Before we look at the options, let us first understand what this question is actually trying to ask. Now, making a documentary film, or any film for that matter, is a way of expression of any person. That is to say, a person is putting forth his ideas and views in a form of a movie. Thus, we can understand that the right which is at play here is the right to freedom of speech and expression. Now, let us look at the options. The first, A, is right to equality. Now, right to equality basically means that all persons are equal in the eyes of law. We can clearly see that there is no correlation between making a film and the right to equality in this question. Hence, answer A is wrong. We'll come back to B later. C reads right against exploitation. Now, right against exploitation includes prohibition of human trafficking, bonded labor, prohibition of employment of children in factories, etc. Again, this is not related, hence is wrong. D, cultural and educational rights. Now, cultural and educational rights are basically provided to protect the interest of minorities, hence this too is wrong. Now, B reads right to liberty and personal freedom. This personal freedom has been guaranteed in the Constitution under Article 19(1), which talks about 6 freedoms. Under this, Article 19(1), Clause A is the right to freedom of speech and expression. Hence, the right answer to this question would be B, right to liberty and personal freedom. Please have a look at the explanation. Question number 17 gives us a situation. It reads, the Supreme Court passes a writ order asking the CBI to complete the investigation of a high-profile corruption case within a time-bound manner. Which of the following writ can be issued by the Supreme Court in this case? Option A is habeas corpus. Now, the writ of habeas corpus is issued when the court directs any authority to present a person arrested or detained before the court to decide the validity and justification of such a detention. Thus, habeas corpus is wrong because it is used as a judicial review of alleged unlawful detention. We will come back to B. C is prohibition. Now, under the writ of prohibition, a higher court directs the lower court to stop hearing a case which the lower court has taken up in excess of its jurisdiction. Thus, prohibition would also be wrong because it is issued in relation to transgressing the jurisdiction. D is quoranto. Now, under the writ of quoranto, the court calls a holder of public office to show under what authority or qualification is a person holding the office in question. Hence, the writ of quoranto will also be wrong. Coming back to B, now the writ of mandamus literally means we command. Under this writ, the court issues a command to an authority directing it to perform a public duty imposed on it by law. Since the writ of mandamus is used to enforce performance of public duties, this would be the right answer to this question. Please look at the explanation for more information. Question number 18 reads, why is the fundamental right to constitutional remedies considered as the heart and soul of the Constitution? Now, the right to constitutional remedy means that any citizen in this country has the fundamental right to approach the Supreme Court of the country or High Court of any state for the enforcement of his or her fundamental rights which have been violated. First statement reads, this right provides for the enforcement of the fundamental rights, which is correct. Second, in case of violation of fundamental right, an individual can approach any court in India. This is wrong. We know that an individual can only approach the Supreme Court under Article 32 or the High Court under Article 226. Hence, the correct answer to this question would be A, 1 only. Please look at the explanation for more information. Question number 19 reads, which among the following minorities in India have been given protection under the fundamental rights of cultural and educational rights? Now, the cultural and educational rights to the minorities are provided under Article 29 and Article 30 of the Indian Constitution. Article 29 reads, any section of citizens residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. Article 30 says, all minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. Thus, we can see that both these articles are talking about religious minorities, minorities based on language, as well as any minority which has a unique culture, script, or language. Now, the first option is religious minorities, which is correct. Second, linguistic minorities. This is also correct. Third, cultural minorities. This too is correct as provided under Article 29. Hence, the correct answer to this question would be D, 1, 2 and 3. Please look at the explanation for more details. Question number 20 is asking, which among the following are non-justiciable rights under the Constitution? The term non-justiciable means non-enforceable. That is, for violation of non-enforceable rights, a person cannot approach the Supreme Court or the High Court under the Indian Constitution directly. We also know that the fundamental rights contained in Part 3 of the Constitution are enforceable. The directive principle for state policy, on the other hand, are non-enforceable as contained under Article 37. Now, the first statement is right to education. The right to education is a fundamental right under Article 21A, hence is enforceable, therefore is wrong. Second, equal pay for equal work. Equal pay for equal work is a directive principle of state policy under Article 39D. Since it is a DPSP, it is non-enforceable, therefore is correct. Third, right to work. Right to work again is a directive principle of state policy under Article 41. Therefore is the right option. Fourth, right to adequate living. This too is a DPSP under Article 39A, hence is correct. Therefore, the correct answer to this question would be C, 2, 3 and 4 only. Kindly look at the explanation for further information. Question number 21 is asking about the features of the proportional representation system of election. Let us look at few of its features. Now, under this system, firstly, large geographical areas are demarcated as constituencies. Under this system, the entire country can also be treated as a single constituency. Secondly, in this system, more than one representative may be elected from one constituency. Under this system, the voter votes for the party rather than the candidate. Fourth, which is one of the most important features of this election system, is that every party gets seat in the legislature in proportion to the percentage of votes that it gets. Also under this system, the candidate who wins the election gets the majority of votes. Such system of proportional representation is prevalent in countries like Israel and Netherlands. Coming to the question, the first statement reads, the entire country may be a single constituency. This is correct. Second, the voter votes for the party instead of a candidate. This too is correct. Third, the seats in the legislature is based on the percentage of votes that a political party gets. This is also right. Hence, the right answer to this question would be D, 1, 2 and 3. Please have a look at the explanation for more details. Question number 22 is asking us to consider three statements with respect to elections in India. The first statement reads, all the elections in India are based on first past the post system. Now, under the FPTP system, whichever candidate secures the maximum vote, that is, secures more votes than other candidates, gets elected. Now, under this system, the candidate need not get the majority of votes. Thus, to simply put, in the electoral race, the candidate who crosses the winning post first of all with more number of votes gets selected. Now, the operative word in the statement is all. This statement is wrong because though majority of elections in India are held through the FPTP system, the election of the President, Vice President and the Rajya Sabha MPs is carried out through proportional representation with single transferable vote. Second, the Election Commission of India conducts and supervises all the elections in India, including the elections for local bodies. This again is wrong. The elections to the local bodies are conducted by the State Election Commission. Third, the Chief Election Commissioner and the other two election commissioners enjoy equal powers. This is correct. The Chief Election Commissioner only presides over the election commissions, but he does not have any extra powers as compared to the two other election commissioners when it comes to taking decisions. Hence, the correct answer to this question would be C, 3 only. Please look at the explanation for more information. Question number 23 is asking, on which of the following grounds can the President be impeached under the Indian Constitution? Now, the procedure for impeachment of the Indian President is provided under Article 61 of the Constitution. According to Article 61, the only ground for impeachment is the violation of the Constitution. The article provides that the impeachment charges can be initiated in either house of the Parliament. For the impeachment resolution to be passed, it requires a special majority in both the houses of Parliament, that is, majority of 2/3 of the total members. Coming to the question, the first statement is violation of Constitution, which is correct as Article 61 only refers to the violation of the Constitution as a ground for impeachment. Second, proved misbehavior or incapacity. This is wrong. Third, undischarged insolvency. This also is wrong. Hence, the correct answer to this question would be A, 1 only. Please have a look at the explanation provided. Question number 24 reads, which among the following correctly depicts the size of the Council of Ministers under the 91st Amendment Act? The 91st Amendment Act of 2003 inserted Clause 1A to Article 75. Thus, Article 75, Subclause 1A reads, the total number of ministers, including the Prime Minister, in the Council of Ministers shall not exceed 15% of the total number of members of the House of People. Thus, the size of Council of Ministers is not more than 15% of the total members of the House of People, that is your Lok Sabha. Now coming to the answer options, A reads, shall not exceed 10% of the total members of the House of People. This is wrong. We will come back to B. C, shall not exceed 10% of the total members of the Parliament. This is wrong. D, shall not exceed 15% of the total members of the Parliament. Now here, though the percentage is correct, but it is not the Parliament, but the House of People. Hence, the right answer to this question is B, shall not exceed 15% of the total members of the House of People. Please have a look at the explanation provided. Question number 25 reads, which among the following are grounds for disqualification of members of Parliament under the Antidefection? The Antidefection provisions were added through 52nd Amendment Act of 1985. The Amendment Act added the 10th schedule to the Indian Constitution. To very simply put, defection means changing party allegiance from the party on which the person got elected to a different party. Under the anti-defection law, two grounds for disqualification are provided. First is that if the member voluntarily gives up the membership of the party, that is, he resigns himself. Second is if he votes or abstains from voting contrary to the directions issued by his party. The law also provides for two exceptions to these disqualification. The first is that if such a member goes out as a result of a merger of his party with another party. Second is that if such a member is elected as the presiding officer of the House and voluntarily gives up his membership for the time being. Coming to the question, the first statement is if a member voluntarily resigns from the party. This is correct. Second, if a member votes against the instructions issued by the party, this too is correct. Hence, the right answer to this question is C, both 1 and 2. Please have a look at the explanation. Question number 26 is asking us to consider three statements with respect to the money bill. The definition of money bill is provided under Article 110 of the Indian Constitution. Now, a money bill can only be introduced in the Lok Sabha. After passing the Lok Sabha, the bill goes to the Rajya Sabha, wherein the Rajya Sabha cannot reject or make amendments to the bill. The Rajya Sabha can only make certain recommendations. The Rajya Sabha has to return the bill within 14 days, with or without recommendations. If it is not returned in 14 days, the bill shall be deemed to be passed by the Rajya Sabha. Further, the recommendations made by the Rajya Sabha can either be accepted or rejected by the Lok Sabha. After passing both the houses of the Parliament, the bill goes to the President for his assent. Now, the President can either give his assent or withhold his assent to the bill, but the President cannot return the bill for reconsideration. Coming to the question, the first statement reads, the money bill can be introduced only in Lok Sabha, which is correct. Second, the Rajya Sabha cannot reject the money bill, but it can only make amendments. This is wrong. We have seen that Rajya Sabha cannot make amendments, it can only make recommendations. Third, in case of a disagreement, there is a provision for joint sitting of both the houses of Parliament. This statement is also wrong. A joint sitting is called to resolve a deadlock between the two houses of Parliament. As we know, in case of a money bill, Rajya Sabha does not enjoy much power and can make only recommendations. Thus, there is no point of holding a joint sitting. Hence, the correct answer to this question would be A, 1 only. Please look at the explanation for more information. Question number 27 reads, which among the following fields can be considered for the nomination of members to the Rajya Sabha under the Indian Constitution? Article 80 of the Indian Constitution provides for the composition of Rajya Sabha. Accordingly, the total membership of the Rajya Sabha is fixed to 250. Out of this 250, 238 are the elected members representing the various states in India. The remaining 12 are nominated by the President. Article 80, Clause 3 says that the President shall nominate 12 members to the Rajya Sabha from the fields of literature, art, science, and social service. The main reason behind nominating such members is so that eminent people can be represented in the Parliament of the country without going through the tedious process of election. Coming to the statements, first is art, which is correct. Second, literature is correct. Third, science is also correct. Fourth, social service is also correct. Fifth, cooperative movement is wrong because Article 80 Clause 3 only mentions these four. Hence, the right answer to this question is C, 1, 2, 3 and 4 only. Please have a look at the explanation. Question number 28 is asking, which among the following cases can be heard only by the Supreme Court and not by the High Courts? Thus, basically what this question is asking is that in what matters does the Supreme Court enjoy exclusive jurisdiction? Article 131 of the Indian Constitution talks about original and exclusive jurisdiction of the Supreme Court. As per this article, the Supreme Court decides dispute between centre and one or more states. Second, the centre and any states on one side and one or more states on the other side. Third, between two or more states. The first statement reads, violation of the fundamental rights. Now, the violation of fundamental rights can be tried both by the Supreme Court and the High Court as well under Article 226. Hence, the first statement is wrong. Second, to a certain constitutionality of a law. That is basically your judicial review. Again, the power of judicial review has been provided to both the Supreme Court and the High Court. Thus, again, the second statement is wrong. Third, dispute involving centre and state. This is correct, as we have just seen under Article 131, centre versus one or more states. Therefore, the right answer to this question is C, 3 only. Please look at the explanation for more details. Question number 29 is asking which among the following features have been provided under the Indian Constitution to ensure the independence of judiciary. Since the judiciary is the custodian of the Constitution as well as the guarantor of fundamental rights, it is imperative that it functions independently without any influence from the executive or the legislature. Now, the first statement reads, security of tenure for the judges. This statement is correct because the judges in India can only be removed by the president. That too on the grounds mentioned in the Constitution. This means that they do not hold their office during the pleasure of the president. Second, judiciary is not financially dependent on either the executive or the legislature. This is also correct. The salary, allowances as well as the administrative cost of the courts in India are charged on the Consolidated Fund of India, hence are non-votable by the Parliament. Third, power of the judiciary to punish for the contempt of court. This is also right. The judiciary in India has been given power to punish any person for the contempt of its court so that it can preserve its authority and dignity, as well as ensure compliance to its orders. Fourth, restraining the Parliament from discussing about the conduct of the judges except under certain circumstances. This is also right. The Constitution prohibits any discussion in the legislature with respect to the conduct of the judges in the country except when an impeachment motion is under consideration. Hence, the right answer to this question would be D, 1, 2, 3 and 4. Please look at the explanation to have more details. Question number 30 is asking us two statements with respect to the public interest litigation. Now, the public interest litigation or the PIL is a product of judicial review in our country. Under a PIL, any public-spirited citizen can move to the court for enforcement of fundamental right of any other person or a group of people. Thus, under a PIL, it is not necessary that a person moving to the court should be an aggrieved himself. He can do so in order to voice the concerns of other socially and economically deprived people. Over the years, the PIL has now helped in upholding the rule of law, facilitating effective access to justice for the socially and economically weaker section of the society, and has also helped in meaningful realization of the fundamental rights. Coming to the question, the first statement reads, PILs have overburdened the courts in India. Sadly, this statement is true because of late, a lot of frivolous PILs have been filed in the courts to meet ulterior motives of people. Second, PILs have expanded the scope of democratic rights in India. This is correct. Hence, the right answer to this question would be C, both 1 and 2. For more information, please look at the explanation.